In discussing proof and defense of psychiatric malpractice, I shall attempt to discuss the liability incurred by medical professionals, clinics, and hospitals, as well as manufacturers of drugs and medical devices and equipment in diagnosing, treating, and caring for psychiatric patients. In 1984, Douglas Danner, who is a nationally recognized malpractice defense attorney, noted in his monograph on medical malpractice the following perspective. He wrote, "The inescapable truth about medical malpractice is that it cannot be completely prevented. Today, even the best trained and most conscientious doctors are finding themselves defendants in medical malpractice lawsuits. This seems incongruous considering the fact that never before in the history of American medicine has so much sophistication and technology been attained in the delivery of health care." Danner also noted that classically there are three factors which often combine to initiate a medical malpractice case: an unexpected bad result, a big bill, and a poor relationship between the patient and the patient's family and the doctor. In psychiatry, ironically, an intimately too good a relationship between the psychotherapist and the patient may in some instances lead to a malpractice lawsuit, even if such intimate therapy is recognized by an exceedingly small but respectable minority. Defense attorneys are well aware of the impact of malpractice lawsuits on physicians' personal and professional life. In 1985, Dr. Sarah Charles and her colleagues of the University of Illinois Medical Center reported in the American Journal of Psychiatry on the impact of medical malpractice lawsuits on the physician's personal and professional life. The authors found that most physicians who are served with a malpractice lawsuit become angry, tense, frustrated, irritable. They don't sleep well, they don't eat well, they develop low self-esteem, and even may have suicidal ideation. The filing of the malpractice lawsuit is disruptive to the physician's professional and personal life, and additionally, the physician's family share the burden of that stress. Even physicians who have not been sued for malpractice may have a great deal of symptomatology and emotional feelings resulting in part from the viewpoint of fear of being sued. Indeed, some of the non-sued physicians may be more symptomatic than those who have been sued because of concern about incidents that could lead to malpractice lawsuits in the future. Defense attorneys are understanding and encouraging and sympathetic towards the physicians that have been sued. However, their job is to attempt to determine the facts in the case and to see through, if you will, the emotions of the physicians that have been sued. We must remember that the plaintiff patient carries a very heavy burden of proof. The burden of proof encompasses the burden of producing or going forward with evidence and the burden of persuasion. It is the plaintiff that has the burden of pleading, of producing or going forward with evidence sufficient to make what is known as a prima facie case. Once the patient plaintiff has satisfied the burden of going forward with the evidence, it is then incumbent upon the physician defendant to come forward with evidence to rebut the accepted evidence. Well, what about the burden of persuasion? After the parties, plaintiff and defendant, have sustained the burden of production of evidence, then the next question is whether or not the party with the burden of persuasion, that is the plaintiff, has satisfied it. The burden of persuasion in a medical malpractice lawsuit is usually the preponderance of evidence, which would tip the scale in favor of the plaintiff. The judge considers three aspects that are very important before admitting evidence for consideration by the jury. First, materiality; second, relevancy; and third, competency. Materiality exists when the proffered evidence relates to one of the substantive legal issues in the case. Relevancy is a question of probativeness. If the evidence tends to prove one thing or make it untrue, then it is relevant. Competency is the requirement that assume that the evidence that is proffered is relevant and material it should not violate some rule that is exclusionary, such as the rule against hearsay. So in preparing his or her case, the plaintiff attorney looks at the checklist of the defenses of medical malpractice and then tries to determine whether or not he or she will get to at least first base. Well, let us review some 24 defenses of medical malpractice, and this is by no means a complete list. First, the physician may counter by saying that the alleged incident, in fact, did not occur. Second, the statute of limitation may have run. The statute of limitation is that period, usually approximately 2 years, during which an injured patient can file a medical malpractice lawsuit. The case in litigation may have been an emergency one, and the physician cannot be expected to act with the same skill and completeness in an emergency as in a normal situation. To encourage physicians to care for patients under emergency conditions, various states have enacted Good Samaritan laws. Thus, a Good Samaritan will not be held responsible if an act involves only ordinary negligence. The physician's misdiagnosis could be the result of an error of judgment. The mere fact that the physician misdiagnoses a condition does not indicate liability for medical malpractice unless it can be proved that this misdiagnosis was the result of negligence. Thus, an erroneous judgment rather than negligent judgment is not a source of liability. In general, the doctor is not liable if there is no physician-patient relationship, or if the patient refuses treatment after being informed, or if the patient is discharged against medical advice. The patient could have been released appropriately by the physician or transferred to another doctor's care. If the incident occurred after the proper release or the proper transfer, the doctor is not liable. In the case of the critically ill or the moribund patient, it is best to have the ethics committee of a hospital review the case. And if that has been done, the decision of the ethics committee would be supportive in defense of the physician defendant. Other defenses include the incompleteness or inaccuracy of the history provided by the patient, or prior diagnoses and treatments that could not be discovered by the doctor. Similarly, an uncooperative patient or family, or a patient that is under the influence of alcohol or drugs, may pose difficulties for the physician in the examination, workup, and observation of that patient. Other defenses include the fact that the treatment rendered was the best at the time, or that the treatment was recognized by a respectable minority, or that the patient had a very unusual anatomy or was extremely obese, making it difficult to make a diagnosis. Also, the law recognizes that under certain circumstances, such as the administration of unavoidably unsafe drugs, unavoidable complications arise. Furthermore, reassurance is not a guarantee. Next, the physician's acts may be protected by law, and the patient may contribute by being negligent, either in whole or comparatively or relatively negligent. Another defense is the intervening factor between the alleged act by the doctor and the resulting damage. If there is an intervening factor that can be the cause of the damage, then the doctor would be exonerated. The patient may assume the risk of a certain treatment that carries hazards or non-treatment. And though not spelled out, there is always an implied threat of a countersuit hanging over the shoulders of the plaintiff attorney and his or her client. Now, the causes of action, or the etiology of medical malpractice, there are many theories that underlie a medical malpractice case, but some generalizations can be made. With respect to us as professionals, the malpractice case may be based upon the following: a breach of contract, a breach of warranty, lack of consent, lack of informed consent, fraud, misrepresentation, abandonment of the patient, assault and battery. But the most common cause is negligence. And a branch of negligence is res ipsa loquitur, which simply means the thing speaks for itself. And there are miscellaneous causes. Among the miscellaneous causes are false imprisonment, wrongful commitment, abuse of the process, defamation, libel and slander, invasion of privacy, disclosure of confidential communications, infliction of emotional and mental distress and vicarious liability for those that work either in our offices as helpers or those that work in a hospital. Let us now turn to recent medical malpractice involving psychiatry. Recent developments in psychiatry have highlighted the liberty interests of psychiatric patients, which are protected by the U.S. Constitution, as well as other constitutional issues. And then we have the least restrictive alternatives, specific psychiatric treatments such as insulin and shock therapy, and duty to warn third parties. Let me talk first about liberty interest. In a landmark decision in psychiatric malpractice, have held that there are substantive constitutional rights, and by applying the Due Process Clause of the 14th Amendment, courts have prohibited the involuntary medication of both non-committed and committed psychiatric patients unless the latter are adjudicated incompetent. In 1977, the U.S. Supreme Court held in Graham versus Wright that the compulsory medication is an intrusion rising to the level of a liberty interest, as well as a deprivation of the freedom of thought protected by the U.S. Amendment, by the First Amendment, and cruel and unusual punishment, which is protected by the Eighth Amendment. And even in emergency situations, emergency cases with medications here, the patients also have been given the clearance. And let us look further on constitutional issues, and first, involuntary commitment. In 1979, the U.S. Supreme Court held in O'Connor versus Donaldson that a person may not be confined involuntarily if he or she is not a danger to anyone and can live safely in freedom. Involuntary commitment of the mentally ill is permitted only when the patient actually injures himself or others, or the patient can be expected in the near future to injure himself or others, when the patient has engaged in recent overt acts or significant recent events that substantiate that allegation, or when the patient is unable to attend to his or her basic needs. Mere acts of destruction of property of the mentally ill are usually insufficient to justify involuntary commitment. Next, involuntary treatment. The U.S. Supreme Court has placed severe restrictions on involuntary treatment of the confined mentally ill patient, even when the patient may be dangerous to himself or others. Treatment should be left in the hands of the irrational patient or the treating psychiatrist. If there is no emergency, then the hospital personnel are in no danger, and the only reason for forcible treatment of psychiatric patients is to help them, and not the general public. The public is protected by commitment of the patient and not by involuntary treatment. Even if the patient is adjudged incompetent, that should not deprive him of a liberty interest in making treatment decisions. But there is the parens patria doctrine. The doctrine of parens patria is an equitable doctrine that is used by courts to empower it to permit parental or guardian consent on behalf of minors or incompetents. And this is done by resorting to this doctrine, and the judge would substitute his or her judgment to benefit the incompetents who are incapable of protecting themselves. There is a popular belief among psychiatrists that the mentally disabled are entitled to treatment under the parens patria doctrine, even if the patients do not recognize that need themselves. However, this view is slow in gaining acceptance in American jurisprudence. What about treatment of patients with the least intrusive alternative? In treating patients, many states require the least restrictive alternative. What is that? The least restrictive mode of treatment was spelled out in Rennie versus Klein in 1978 and was affirmed in Rogers versus Oken in 1980. Here, the patient's liberty can be diminished only to the extent necessary to allow for confinement by the state so as to prevent him from being a danger to others and to himself. The least intrusive mode of treatment is actually a refinement of the 1960 doctrine of less drastic means, which was introduced by the U.S. Supreme Court in Shelton versus Tucker. And what about the residuum of liberty concept? In 1977, the U.S. Supreme Court, in the case Ingram versus Wright, set forth the concept of residuum of liberty, which was expanded in the Rennie Court. Under this concept, psychiatric patient keeps the right from being intruded on and on his security. Involuntary medication of psychiatric patients with antipsychotic drugs has been severely curtailed. Thus, an adult who has not been adjudged incompetent, but who is involuntarily committed, say in Arizona State Hospital, has a right to refuse, even in emergency situation, to take antipsychotic drugs prescribed for his treatment. The Arizona Court of Appeals ruled in repetition for court-ordered treatment of Matthew Anderson in 1982 that antipsychotic drugs can only be administered in strict accordance with Arizona's Mental Health Act. The court also concluded that the administration of antipsychotic drugs to the patient was a pharmacological restraint to which he cannot be subjected. The patient has a right to refuse treatment. Now, as to commitment and competency determinations, some states by statute allow for bifurcation, separating the commitment from competency hearing. By separating the two proceedings, there can be a thorough consideration by the court of the available treatment alternatives to hospitalization. Such alternatives to hospitalization would include outpatient clinic, extended care facilities, nursing homes, sheltered care arrangements, homemaker services, as well as other programs or suitable arrangements. The purpose of these programs is to allow for minimal curtailment of the mentally ill patient's rights. But this minimal curtailment of the patient's right have been blamed for the revolving door policy, which allowed the mentally ill to roam freely and engaged in rampant crime between numerous periodic short-term commitments. Now let's look at some specific psychiatric treatments. Psychiatric malpractice cases have included a large number of lawsuits which result from failure on the part of the psychiatrist to provide informed consent. For example, both physician and hospital have been found liable where brain damage resulted from insulin shock therapy. Psychiatrists have been found liable for failure to warn of the risk of fractures and heart attacks during electric shock therapy, and for failure to provide muscle relaxants during such therapy. Courts have generously compensated the institutional patients that have been attacked sexually. The test here is whether the psychiatrist is blameworthy or not, is whether the homicidal tendency or homosexual tendency were known or should have been anticipated by the psychiatrist. Wet back treatments. These involve immersion of manic depressive patients in 94 to 96 degrees for up to 6 hours. And then this can be repeated on an as-needed basis. Wet pack treatments have been characterized as the most modern and humane methods that have been devised for the restraints of the manic depressive. In 1953, in the case of Powell versus Rissery, I think, the patient, manic depressive, was immersed for the second time in hot water, and he developed blisters and swelling of the hands. The psychiatrist was not present at the time of the immersion in hot water. The court held that the evidence was insufficient to sustain the finding of negligence on the part of the psychiatrist, who did not need to be present during the entire time of wetback treatment. What about intimate therapy or fornication? In 1968, in a Michigan case, Nicholson versus Hand, a psychiatrist escaped a determination of malpractice for intimate therapy. There, the psychiatrist was not held liable for breach of contract or fraud because the two causes of action pleaded by the patient's husband were, in effect, alienation of affection and criminal conversation, and both types of litigation had been abolished by a state statute. In several cases, the psychiatrists have been charged with malpractice for intimate therapy. In addition to malpractice litigation, emotional entanglement between psychiatrists and the patients have led to criminal prosecution for rape in several instances where the patient was found unable to give informed consent. In an interesting case, a psychiatrist sued an insurance company for failure to reimburse him for sexual ministrations which he performed on a female patient because, in his opinion, those intimate ministrations were therapeutic and her psychological stability apparently included the need for copulation. Cases of intimate therapy appear most commonly in litigation involving revocation of licenses to practice medicine involving allegations of moral turpitude or gross immorality. Courts have also found psychiatrists and others to be grossly negligent to recommend extramarital intercourse for a female patient even if the physician himself did not volunteer to fill that prescription. In one case, the physician was successfully prosecuted for promotion of prostitution. You know, the psychiatrist needs to read his insurance policy also. Today, most malpractice insurance policies do not cover intimate therapy. Another area of proof of psychiatric malpractice involves the duty to warn, perhaps the most significant intrusion of law into the practice of psychiatry and the long-accepted psychiatric psychiatrist privilege has been the decision of the Supreme Court of California in the case against the University of California in 1974. Here, in this case, we are dealing with an injured third party a la Tarasov. The Tarasov decision asserts that a psychiatrist or a psychologist who learns that a patient intends to kill a third person has a duty to warn such a person. If he does not, he incurs liability for the death of the victim when the patient carries out that threat. In defending the psychiatrist for malpractice, the defense attorney may look to the manufacturer for possible liability for drugs used by the psychiatrist or some medical devices. The manufacturer may be liable on the theory of negligence, which is tort, strict liability, which is again in tort, or in contract for breach of express warranty or breach of implied warranty, such as implied warranty for merchantability or implied warranty of fitness for a particular purpose. And what about hospital duties in treating the mental cases? Psychiatric institutions and hospitals have been named in many lawsuits involving psychiatrists. But there are specific instances where the hospital is particularly liable, such as failure to control dangerous patients and failure to appropriately exercise control of such psychiatric patients to the detriment of others who have been injured as a result of such behavior. And this is particularly true where the violent behavior is foreseeable. Failure to prevent suicide has also been a source of liability of hospitals. In almost all jurisdictions, hospitals have been found for failure to prevent patients from escaping and committing suicide, where the suicidal tendencies were known and where evidence showed failure on the part of the hospital to confine the patient. Furthermore, when a psychiatric patient communicates a specific suicide plan, to a hospital staff member, failure to inform the staff psychiatrist constitutes a breach of duty and renders the hospital liable for negligence. And this is also important to know, that hospitalized patient must have a safe and secure confinement. Now what about negligent releases and elopements? Courts in many jurisdictions have held hospitals liable for assault on other patients and or injury caused to the public by mental patients who were carelessly released from the hospital or for lack of supervision succeeded in escaping from mental institutions. In 1975, in the case of Hicks versus United States, a government hospital was held liable for negligently releasing a mental patient who subsequently murdered his wife. And in 1982, in Payton versus United States, a patient with a 15-year history of brutal beatings of females was released on parole and custody, and shortly thereafter he brutally beat and mutilated 3 females. The court found the United States liable for disregarding extensive medical records confirming the patient as a homicidal psychotic. The court said that his release on parole was a grievous error bordering on gross negligence. Now, in a variety of cases in the United States, mental institutions and psychiatrists were sued by third party for injuries inflicted by escaped patients, whether they stabbed or killed in many ways. And in reviewing these cases, courts have uniformly found liability where the homicidal tendency was known or where there was an anticipated of such behavior. Now, in a case versus Sentinel versus New York, there was no liability where there was an honest error of professional judgment by qualified physicians that released the patient. Courts have defined negligent release where there can be a cause of action for the negligent release of the patient who has violent propensities, and these have been distinguished from negligent failure to warn persons that might be injured by those patients because of the negligent release. Thus, negligent release and the duty to warn are 2 separate causes of action. And as to the employees of a hospital, hospital may be vicariously or corporately liable for actions of the employees of the hospital, and in some instances, hospitals have been found liable for the injuries as produced by independent contractors who are doctors.